The recording has started.
Chair Yankee, would you like to introduce the meeting?
Sure. So I'm calling to order the special remote meeting of the City and County of San Francisco's Sunshine Ordinance Task Force. This is October 5th, 2022. Cheryl, if you'd like to read the preamble and then the meeting decorum, please.
Okay. Remote access to information and participation. In accordance with Governor Newsom's Executive Order N3320, declaring a state of emergency regarding the COVID-19 outbreak, and Mayor London N. Breed's proclamation declaring a local emergency issued on February 25, 2020, including the guidance for gatherings issued by the San Francisco Department of Public Health Officer, aggressive directives were issued to reduce the spread of COVID-19. On March 17, 2020, the Board of Supervisors authorized their board and committee meetings to convene remotely via Microsoft Teams and will allow remote public comment via teleconference. Members of the public may participate by phone or may submit their comments by email to cheryl.leger@sfgov.org. All comments received will be made a part of the official record. Sunshine Ordinance Task Force agendas and their associated documents are available at sfbos.org/sunshine. As the COVID-19 disease progresses, please visit the Sunshine Ordinance Task Force website regularly to be updated on the current situation as it affects the legislative process. Meeting decorum. Any member of the Sunshine Ordinance Task Force may call for decorum due to disorderly conduct of meeting participants. Persons who engage in threatening and/or menacing behavior may be asked to leave.
Okay, thank you, Cheryl. If you want to proceed to item number 1.
Item number 1, call to order, roll call, and agenda changes. Roll call. Member Wolf. Member Wolf is
Present.
Oh, you're present.
Present.
Great. Member Wolf is present. Member Hill, not present. Member Neighbors.
Member Neighbors is going to be absent on this one.
Member Highland.
Present.
Member Highland present. Member Stein.
Present.
Member Stein present. Member Pomenaben. Not present. Member LaHood.
Present.
Member LaHood present. Member Schmidt.
Present.
Member Schmidt present. Vice Chair Wong absent. Chair Yankee.
Present.
Chair Yankee present. 1, 2, 3, 4, 5, 6. We have 6 people present. We have a quorum.
Okay, great. Any agenda changes, Cheryl?
I have not been made aware of any agenda changes at all.
Okay, and I'm not aware of any either. So let's go ahead and proceed on to, well, see, I guess we could take public comment on that.
We do?
I'll call for it. I'm not sure if anyone will have public comment, but.
All right, let me get to my draft.
Yes, if there's anybody who would like to make public comment on the announcement that was just made regarding agenda changes, you can raise your hand now by pressing *3 to raise your hand, or otherwise indicate that you'd like to speak. I had someone just log in. If it was one of our members, if you can also raise your hand so I can identify you, it would be appreciated. I'm not seeing any hand raised at this time.
Okay, great. So we'll go ahead and close public comment for that. And Cheryl, you can move on to item 1A.
Hang on. Item 1A, findings to allow teleconference meetings under California Government Code Section 54953. E as in Edward. The task force is expected to consider a motion setting forth findings required under Assembly Bill 361, that's AB 361, that would allow the committee to hold the meeting remotely according to the modified Brown Act teleconferencing set forth in AB 361.
Okay, members, this is the standard motion that we have. Does anyone want to move to approve this?
I'll make a motion to approve it.
Okay, so moved by
This is
member
Member
Stein.
Stein.
We have a second?
Member Wolf, second. Member Wolf, second.
Okay, so member Wolf seconded that. So moved by member Stein, seconded by member Wolf. Let's see, if we have any public comment on that? If anyone has public comment on this, go ahead and raise your hand. I believe it's *3. And Victor, I'm assuming no public comment?
I am not seeing any indication for public comment. If you did want to make public comment, you can *3 to raise your hand at this time. I'm not seeing any raised hands.
Okay, so we'll go ahead and close public comment. I don't see any discussion from the members, so we can go ahead and move to a vote on this. Cheryl, when you're ready.
Member Stein.
Aye.
Member Stein, aye. Member Wolf.
Aye.
Member Wolf, aye. Member Schmidt.
Aye.
Member Schmidt, aye. Member LaHood.
Aye.
Member LaHood, aye. Member Padmanabhan. Member Padmanabhan, not present. Member Highland.
Aye.
Member Highland, aye. Member Neighbors, not present. Member Hill, not present. Vice Chair Wong, not present. Chair Yankee.
Aye.
Chair Yankee, aye. 1, 2, 3, 4, 5, 6. 6 in favor.
Okay, 6 ayes and 4 absent on that.
Right.
Okay, so let's go ahead and move to the next item, item number 2.
Item number 2, approval of the minutes from the Sunshine Ordinance Task Force, August 3rd, 2022, regular meeting.
Okay, and Cheryl, I believe these are ones that we had continued in a prior meeting. Did you have any comments on what was changed?
I did, and I made the changes.
Okay, so these have the changes. Do you recall what
These
they
are
were?
the changes, yeah.
Okay. Members, any comments on this? Should we move to approve?
Motion to approve.
Okay, so moved by Member Schmidt. We have a second. Any second to approve the minutes? All right, I'll go ahead and second.
This is
that.
member
Oh,
member
I'm
LaHood.
sorry.
Second,
I'll defer to you, Member LaHood. Did you want to second it? Okay,
Yes.
we'll give that one to Member LaHood. So moved by Member Schmidt, seconded by Member LaHood to approve the August meeting minutes.
Okay, if you'd like to make public comment on this matter, you can go ahead and raise your hand at this time. We have one hand raised by pressing *3. Looks like this person's already unmuted. So if you did raise your hand, you can announce yourself and Cheryl can begin the timer.
Hello? Can anyone hear me?
We can't.
Yeah, we can hear you.
Okay, this is anonymous number 3.
Cheryl, when you're
Ready,
ready,
sir? Sir, are these comments to the minutes, or are you going to suggest changes that I can write down, or how do you want to do this?
I was just going to give my comment like normal. Should I do something else?
No, it's okay.
This is public
I-
comment, just you can time his 3 minutes, and if he happens to have recommendations, it is part of the public comment.
Yeah.
Understood. All right,
All right.
all I was going to, should I start?
Go ahead.
Thank you very much. All I was going to suggest is, it says that I have requested the committee to find a violation in all of my cases, probably the other people's cases too. It should say the task force. These aren't committee hearings. That's all. Thank you.
Can you provide an example where you say that so that I make sure that I?
Certainly. On page 12 of the PDF, which is footer page 16 or right corner page 11, it says, Anonymous provided a summary of the complaint and requested the committee to find a violation.
On my hard copy, page 12, you're saying?
I don't know what page it is in your hard copy. It's the PDF page 12.
Oh, it doesn't help.
That's just one example. It's the same issue throughout the minutes.
And all right, so what change do you want to make? Because I was trying to find it.
Sure. So I'm suggesting that each place where you have written that the petitioner or complainant, quote, requested the committee to find a violation, end quote, it should read, quote, requested the task force to find a violation, because these aren't committee hearings. Because only the task force can find a violation, the committees can't.
I just wrote it down. So I'll take a closer look at these minutes. Thank you very much for your suggestion.
I'll
Okay,
amend my motion to incorporate that.
okay, so
Okay, there is no other public commenters at this time. So I believe Member Schmidt is amending his motion if the second would agree to that.
Member
So,
Hood, is that,
Member Schmidt, you're moving to approve the minutes with suggested changes from anonymous. Is that correct? Okay. Okay, I wrote down what he said. I'll take a closer look at the minute.
and Member LaHood, is that acceptable to you as the seconder? Okay, I see Member LaHood nodding, so.
Yes, sorry, I'm muted.
Okay, see no further discussion or hands, I think we can go ahead and move to a vote on that motion.
Member Schmidt.
Aye.
Member Schmidt, aye. Member LaHood.
Aye.
Member LaHood, aye. Member Padmanabhan. Absent. Member Stein.
Aye.
Member Stein, aye. Member Highland.
Aye.
Member Highland, aye. Member Neighbors, absent. Member Hill, absent. Member Wolf.
Aye.
Member Wolf, aye. Vice Chair Wong, absent. Chair Yankee.
Aye.
Chair Yankee, aye. 1, 2, 3, 4, 6. Okay, 6 in favor.
Okay, great. Cheryl, when you're ready, we can move on to the next item.
Item number 3, approval of the minutes from the Sunshine Ordinance Task Force, September 7, 2022. Get my copy.
Okay, so members, this is the first time these minutes are appearing on the agenda. Does anyone have any edits to these?
I don't.
Okay, I'm not seeing any. So I'll go ahead and make the motion on this one to approve the September meeting minutes.
I'll second that. This is Member Stein.
Okay, so moved by Chair Yankee, seconded by Member Stein to approve the September meeting minutes. We're ready for public comment on this.
If there are any members of the public who would like to make public comment, you can go ahead and raise your hand. We currently have one person with their hand raised. I will go ahead and unmute them.
Okay.
May I begin? This is anonymous number 3.
You ready, sir? Because I'm going to write down
Yeah.
what your suggestions are. Okay,
Yep.
go ahead.
Thank you very much. On PDF page 8, which is footer page 28, which is right-hand side page 7, the motion regarding Dennis Herrera has typos in it. It says, moved by Member Wolf, seconded by Vice Chair Wong to find that to find. So that should be corrected from a grammar perspective.
All right,
It's
item
the-
what? Item what?
Item 7, paragraph 1, 2, 3, 4. Fourth paragraph, sentence 1, paragraph 4,
Yeah, I
item
see
7.
Yep.
Okay, and the summary of my comments is very little in it, but I would say there's an error in it. It says same request on paragraph 2, sentence 2. It says I made the same request. No, it's the same type of request. And in sentence 3 in that paragraph, there is no reference to Order 19108, which is what is being referenced there. So it should say that. Sorry, that's it. Thank you.
Okay, I'll listen to the tape.
I do not see any other parties with their hands raised at this time.
Okay, so we'll go ahead and close public comment. And I will restate my motion to approve the September meeting minutes with the suggested edits from Anonymous. And if the seconder agrees.
I agree.
Okay, and the seconder, Member Stein, agrees. So Cheryl, when you're ready, we can go ahead and vote on that.
Okay. Chair Yankee.
Aye.
Chair Yankee, aye. Member Stein.
Aye.
Member Stein, aye. Member Schmidt.
Aye.
Member Schmidt, aye. Member LaHood.
Aye.
Member LaHood, aye. Member Padmanabhan, absent. Member Hyland.
Aye.
Member Hyland, aye. Member Neighbors, absent. Member Hill, absent. Member Wolf.
Aye.
Member Wolf, aye. Vice Chair Wong, absent. So 1, 2, 3, 4, 5, 6 in favor.
Okay, so that has passed. Okay, Cheryl, when you're ready, we can move on to the next item.
Oh, sorry. Item number 4, approval of the orders of determination. We have our ODs from August 3rd and September 7th.
Okay, so members, just a quick change about why this is now appearing on the agenda. Two main reasons. Number one, ordinarily the chair was signing these and there was a lot of back and forth. So putting them on the agenda allows us to, everyone to see them, allows members of the public to see them, and allows us to just kind of improve them all at once instead of each email back and forth. Number two, the other benefit is that we've had issues where meeting minutes have had to have been continued for reasons that don't necessarily have to do with the motions themselves. And that's delayed us processing those ODs since the entire set of meeting minutes weren't approved. So by putting these on separately, if we need to go back and for whatever reason continue a set of meeting minutes, we could separately approve the OD and at least get that done while we're waiting for the corrections on, let's say, public comment or something that doesn't have to do with a particular case. So that's why those are on here. They're pretty much straightforward. We're just including basically the relevant motions that were made regarding each file that we heard. I would note that we did, at the last minute here, I received an email from Anonymous noting some errors. So I'm going to talk about those first, Cheryl.
I hear you.
When you're ready for those. Okay, so the first one is the OD for Arnold Townsend, and this is, I'll let you know what page it is, 1 second here. Okay, so this is going to be for file number 22037, and this is the one with 44 as the page number at the bottom.
Okay, I'm looking at the text of the OD. I just printed them out.
Okay, so it's the one for, okay, so if you look at the final motion, it says moved by Chair Yankee, seconded by Member Wolf to order that a representative of this Department of Elections search Charles Young's email. That motion is for Charles Young's OD, not for obviously Arnold Townsend's OD. So you'll need to grab the proper motion on that one and put it in there.
Can you repeat what you said? I'm sorry.
Yes, so the one for Arnold Townsend, this is 22037.
Yeah, I'm looking at the last motion.
Yep, the second page.
Right.
Okay. The final motion, it says moved by Chair Yankee, seconded by Member Wolf.
Yeah.
Order that a representative of the Department of Elections search Charles Young. So this is about Arnold Townsend. So you accidentally grabbed a motion from the Charles Young matter and put it in this OD.
Okay, so this should be Townsend.
Yeah, don't just replace the name because the motions were different.
No,
So
I know the difference.
Yeah, they're different. So make sure we swap that one out. And then the second one, which is the OD for 22056. So let me know when you get that one. That's the one for Jarrett, with naming both Townsend and Reiner.
Colonel Townsend, Ditka, Reiner, yeah.
Yep. So that one there, there was a motion that had failed that was not included. That was to, I believe I had made a motion to search. It was similar to the other motions that had passed. I believe it's in the meeting minutes, but it didn't make it into here. So we'll want to make sure that motion that failed made it into here. It was similar to the other ones where we asked, the various departments to search the email and to reach out and all that.
Yeah, I made a note to myself. Yeah.
Okay. So since the meeting minutes are approved, Chair, we can always approve those the old-fashioned way, where you send those corrections to me and I can go ahead and sign those once those corrections have been made, since we've done that before and the meeting minutes are now approved. So that's not going to be an issue in this. And then I'd note also that OD 21153, which is the anonymous versus Dennis Herrera one, is missing. That was not included here. So I can do that one the old-fashioned way as well. So with all that being said, is there any further discussion? Okay, so I will go ahead and move to approve the attached orders of determination, except for 22037 and 22056, and ask that you send me those orders to me directly to approve after the edits have been made.
Okay.
Okay, so moved by Chair Yankee, seconded by Member Schmidt. And we can go ahead and move to public comment on that.
Yes. So if you'd like to make public comment this time, you can press *3 to raise your hand. I'll go ahead and unmute our caller.
Anonymous number 3, please let me know when I may begin.
Go ahead, sir.
Thank you very much.
Suggestions?
I'm sorry, what?
No, I'm ready for your suggestions.
I'm not making a suggestion here. I was just going to say I think this is a great idea, and doing these in public where nothing's behind the scenes. It's actually great. It's great that it's also been moved up to no more. It's 1 month afterwards, right? It's not many months later. I do think the chair. I would suggest that the chair go back. There's like a gap of a few months where there were neither emails being sent out immediately after the meeting, nor still are there missing ODs published to your website. And so I do urge the chair to talk with the administrator, because a lot of people's like ODs for a few months in there that were just missing, both in any fashion. So please do check those and then maybe have them come here. Maybe it'll be a bunch of them. And there's a lot of old cases that can finally have their ODs. Thank you.
Do we have any other public commenters?
No, there are no additional hands raised at this time.
Okay, great. We'll go ahead and close public comment. And to Anonymous, yes, I'm aware that there are several ODs that still need to be issued, and so we'll be working our way backwards on those. I want to make sure that the ones that were most recent were on here, just in case for whatever reason the meeting minutes didn't get approved, that we could get these done, and we'll work our way backwards and get those done as well under this new format. So, okay, any further discussion on this item? Seeing any hands, so let's go ahead and move to a vote on that.
Chair Yankee.
Aye.
Chair Yankee, aye. Member Schmidt.
Aye.
Member Schmidt, aye. Member LaHood.
Aye.
Member LaHood, aye. Member Padmanabhan. Absent. Member Stein.
Aye.
Member Stein, aye. Member Highland.
Aye.
Member Highland, aye. Member Neighbors, absent. Member Hill, absent. Member Wolf.
Aye.
Member Wolf, aye. Vice Chair Wong, absent. 1, 2, 3. Why do I only have 3, 4, 5, 6? No, yeah, 6. We got 6 in favor.
Okay, great. So that is approved. Okay, Cheryl, I think we're on to the next item.
Okay. Item number 5, administrators report, complaints, and communications. So it's a big report this month. So let's just start at the beginning. So we have a long list of meetings that are tentatively scheduled to take place. I want to talk about November 22nd, which is the Tuesday before Thanksgiving. Member Highland, do you think we should go forward? And we should ask the whole committee if we should go forward not only for the Thanksgiving holiday, but the day, 2 days after Christmas. I think the 26th, the city is closed, and the 27th, it would be the Compliance and Amendments Committee. So we should probably talk about those days and if we're actually going to meet. Any comments?
Cheryl, unfortunately, I think we just have Chris here for Member Highland for EOT, and then I think it's just Member LaHood for CAC. So unfortunately, without the other members, I'm not sure we can come to a good consensus here. But maybe Member Highland and Member LaHood have some thoughts.
Maybe query those committees by email to see if they can make it.
I am personally available, but I can't speak for my fellow committee members. This is Member LaHood.
The next, on October 25th will be CAC meeting as well, so we don't have to worry about October. That's not the issue. December 27, you're available, Member LaHood.
Technically, yes.
At this point. Member Highland, what about EOT November 22nd?
I should be available, but again, I can't talk for Jaya, who's not here this evening, and I can talk for the third member who we don't have, who is not available. There you go. We're only a committee of 2 at this point.
Okay, well, I will send out an email tomorrow asking for her availability.
Perhaps I could ask Victor. I seem to remember certainly when it falls within one day of a public holiday, we've always, postponed, and we're at 2 days on this case. So not quite sure what our precedent has been. What do the other boards and commissions do typically?
My apologies. I'm not sure what the context is about. Is this about scheduling meeting dates?
Right. Typically when a meeting is within 1 day of a public holiday, we tend to postpone. But in this case, we're 2 days.
Completely at the discretion of the body itself. There's really no rule or procedure for that. You can make your own determination.
Right. That's a good dodge, Victor. What I'm asking you is, what do other bodies do? I mean, just typically, what's the precedent? What does Board of Supervisors, what does Rules Committee typically have done? I'm calling on your institutional knowledge here.
It depends on the chair. I've had Peskin tends to cancel the meetings. I've had others, if there are important matters going on, they'll just go forward and meet. There's really no
rhyme or reason.
Okay. It's better to err on the side of caution and cancel the meetings, just because a lot of the people out in the public tend to schedule their vacations around the holidays. And when we start scheduling people around the holidays, they tend to request postponements.
Right. Yeah, the actual petitioners and respondents. Got it. Yeah, fair enough. So I think I mean we still have a bit of lead time. Maybe we pull them as well, not just us. I mean, for us we're in different times. We're doing this all remote, so that's why I can say yes, I'm available. I might be in Tahoe or I might be somewhere else. Hopefully my connection is good enough, but essentially I'm available. So that's my answer.
If it helps, Member Highland, I'm looking for last year, and it looks like the week of Thanksgiving was CAC's meeting, and they did meet that Tuesday, actually.
I think it was a light calendar.
Yeah, I think yeah.
I don't know. I mean, given backlogs, I would say let's meet if we can. A week lost is justice delayed, as I can hear some speakers saying. But yeah, so I would say if Jaya was here and she said yes, then I would say yes. Let's schedule EOTC, but she's not here to respond. So, but I think it probably wouldn't hurt for our administrator to poll the people that are likely going to be on that calendar and get 100% affirmation that they will be there, or move on to the next person, just so we don't end up showing up and then having no shows. Yeah.
I think it's a great idea. So Cheryl, can you do that?
Yeah, I have to draft an agenda for EOT. We can do that. I can draft an agenda.
I believe we will go ahead and draft an advance agenda. We'll put a few extra people on there just to be sure. And we'll see. We'll make sure we let them know it's tentatively scheduled and not set yet, depending on what kind of response we get. And then if we can get a full agenda, we'll go ahead and leave it up to Chair Highland to decide if we want to move forward.
Sounds good.
Sounds good. Thank you.
Okay. So the second part of the report, I have itemized the cases that came up that were new. Item 3, pending petitions complaints. Kind of interesting. This month and last month's pending task force complaints were the same number. Some, as you all know, some cases were closed, some cases went forward. But I just thought it was kind of interesting that it's the same number this month as it was last month. Updates from committees. Complaint committee minutes were provided. And we had several public communications, mostly from our friend Anonymous. But we also received one from Mark Sullivan and one from Mr. Hillier. And this month, the record of emails, not including emails having to do with administration, was a total of 299, which is about 60 more than last month. Then I provided the complaint committee minutes, the public comments, and then at the very end, I provided a list of the emails that I received in September. Happy to answer any questions.
Okay. Thank you, Cheryl. And one communication I received that I don't believe was in time for inclusion here, and that was just notification that DCA David Reese has left his employment with the city, so he will no longer be our co-legal counsel. So as of right now, it's just going to be DCA Mark Price Wolf. He'll remain with us. I don't know if there's going to be a co DCA or not who will be assisting us, but that's the quick update on that. Okay, not seeing any hands, so if we want to go ahead and move to public comment on that. Victor, are you ready for public comment?
My apologies, I was muted. If you'd like to make public comment on this matter, you can raise your hand. by pressing *3, otherwise using the application. We have Anonymous who would like to make public comment at this time.
Can you hear me? Excuse me.
Yes. We can hear you.
Hello?
You
We
ready?
can
Thank
hear
you.
you. Yeah.
Let me know when I'm able.
Go ahead, sir.
Thank you very much. I think if you look at the amount of emails and other work that Ms. Leger has to process, it would go towards the administrative report, so I'm talking about it here, whether or not the Office of the Clerk of the Board has fulfilled her duties. I'm talking about Clerk Calvillo, not specifically any particular staff member who reports to her, to provide sufficient resources, equipment, and staff to the task force to conduct its business. And I've written to you about this. You have discussed it at a meeting in the past. I think it needs to be re-raised. Just having some more administrative support would make things go more smoothly. And I think you are entitled to it. And Clerk Calvillo should provide it to you. Thank you.
I do not see any additional hands raised at this time.
Okay, thank you, Victor. We'll go ahead and close public comment on this. And no action on this item, so I think we're all set. We can go ahead and move to item number 6.
Second. Item number 6, bylaws amendment, parental leave policy. Hearing to amend the Sunshine Ordinance Task Force bylaws pursuant to Administrative Code Chapter 67B. On September 7, 2022, the task force moved to authorize the chair to work with the administrator to finalize the sample language of our bylaw amendment and bring it to our next meeting for approval.
Okay, thank you, Cheryl. So members, this is the item that's returned from our prior meeting. If you open the attachment and look on page 227 and 228, that's the addition of the new bylaw language that was suggested by our legal counsel. It's the underlined portion there. It's section 4 under article. So it's Article 2, Section 4. So this, I've been told by Cheryl, this has been properly noticed. We had it on our main website, and so this is ready for approval unless anyone has any further edits or concerns.
I just want to also let everybody know that it was posted physically right outside the door of the Board of Supervisors boardroom.
Okay, great. Thank you, Cheryl. Okay, so I'll open it up to a motion if anyone's so inclined.
Yeah, I thought it looked appropriate. So this is Member Stein. I will make a motion to approve.
This is Member LaHood. I'll make a motion to second.
Excellent. So we have moved by Member Stein, seconded by Member LaHood to approve the bylaw amendment.
If there's any members of the public like to make public comment at this time, you can go ahead and raise your hand by pressing *3, or otherwise using the application to raise your hand. I will give parties a few moments. I'm not seeing any hands raised at this time.
Okay, thank you, Victor. We'll go ahead and close public comment. Members, any last minute discussion before we vote on this? Not seeing any hands. So Cheryl, when you're ready, you can go ahead and call the roll.
Hang on a second. Member Stein?
Aye.
Member Stein, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Schmidt?
Aye.
Member Schmidt, aye. Member Pavanabhan, absent. Member Hyland?
Aye.
Member Hyland, aye. Member Neighbors, absent. Member Hill, absent. Member Wolf?
Aye. Aye.
Member Wolf, aye. Vice Chair Wong, absent. Chair Yankee?
Aye.
Chair Yankee, aye. 1, 2, 3, 4. 6 in favor.
Okay, so that's been approved. Great, we can move on to item number 7.
Item number 7, public comment. Members of the public may address the Sunshine Ordinance Task Force on matters that are within the task force jurisdiction, but not on today's agenda. Public comment shall be taken at 7:45 p.m. or as soon thereafter as possible, and will be reopened at 8 p.m. or as soon thereafter as possible for those members of the public who are unable to provide public comment earlier.
Okay, and it's 7:47, so we are right on schedule to take public comment.
Any members of the public like to make public comment this time, you can go ahead and raise your hand by pressing *3 or otherwise using the application to raise your hand. We have 2 members of the public who have raised their hands at this time. I'll go ahead and unmute the first one.
Good evening. It's anonymous number 3. Please let me know when I may begin.
You ready, sir?
I am.
Go ahead.
So I'm going to attempt a new strategy to deal with just the numerous sunshine violations by various public officials. As you know, under Admin Code 6735D, if in 40 days there is no action on one of my complaints, I can simply take it to the Ethics Commission. And so my intent is to take the dozens of my complaints still outstanding before the task force, except where they involve the most senior public officials, Breed, Herrera, Chu, the supervisors, and the chief of police, and take all of them and send them to the Ethics Commission. And we all know the Ethics Commission is going to do absolutely nothing. But the purpose of this is going to show that the Ethics Commission simply ignores the Sunshine Ordinance. They ignore the law, and they simply don't enforce it, even though Admin Code 6735 allows me to do this. And so we were going to see, right, is the Ethics Commission actually going to comply with the law? I know you've all discussed it many times. It apparently never does, and we'll see what they do. So that's my plan. The most important complaints, there's still a few corruption-related complaints after the second one on your hearing docket today. I will be leaving before the task force because that allows a public hearing while the Ethics Commission does not. But the rest of them, we're going to see if the Ethics Commission actually takes any action whatsoever if I show them repeated over and over violations by the same public officials, including when your ODs already exist. Thank you.
Okay, moving on to the next caller. I'll go ahead and unmute the next one.
Sullivan.
You ready, sir?
Yes.
Go ahead.
Task force hearings should not be heard as a debate between the petitioner and the respondent, weighing both sides equally. When a complaint is received, it should be presumed to be true. This is what the soft procedures say. All inferences and evidence shall be viewed in the light most favorable to the petitioner. The agency has the burden of justifying the denial of access. The courts have stated this multiple times, like in Williams versus Superior Court. The Sunshine Ordinance, Section 67.21E, last line, an authorized representative of the custodian of public records requested shall attend any hearing, and this is important, explain the basis for its decision to withhold the records requested. The question the task force needs to ask every respondent is, what part of the law are you citing to support your decision for your action or inaction? Then you should decide if the respondent is applying the law correctly. Everything else is unnecessary verbiage if it is not based on the law or a court case. Listening to anything else wastes time and should not be the basis for a task force decision. The task force should conduct itself more like a court. Section 6721G. In any court proceeding pursuant to this article, there shall be the presumption that the record sought is public, and the burden shall be upon the custodian to prove with specificity the exemption which applies. Cutting out the debate-like atmosphere and cutting to the chase of burden of proof onto the respondent, the specificity of the law which applies will shorten your hearings. You will make better decisions and get more sleep. I wish Anonymous the best tonight. The burden is on the respondent to explain the basis for their decision with specificity of the law. Thank you for your time.
Thank you. I will go ahead and move on to our next caller at this time. Caller, you have been unmuted. You have your hand raised, and I have just unmuted you. You can go ahead and begin your comment.
Okay. Thank you, Mr. Chair. Ladies and gentlemen, the Behavioral Health Commission continues to commit the very same violations of the Sunshine Ordinance, which you found against them on on October 6th of 2021 and February 2nd and April 6th of this year. They continue to include on their agendas open-ended items that do not provide a meaningful description of the discussions that occur thereunder. They continue to conduct regular meetings for which no notice was posted to the public at least 72 hours in advance. They continue to fail to label items on the agenda correctly with the substantial action proposed to be taken or a statement that the item is for discussion only. They continue to fail to reference any explanatory correspondence relevant to an item anticipated to be discussed at the meeting on the agenda. They continue to fail to post any such explanatory correspondence provided for distribution to all the members of the policy body on their website. And they continue to fail to include opportunities for the public to address them on every item on the agenda. The Compliance and Amendments Committee held a hearing on the Behavioral Health Commission at their last meeting on August 23rd of this year. However, shortly before the hearing, the Deputy Director of Behavioral Health Services placed a telephone call to your administrator. The next thing I knew, the item was on the agenda without a proposed action to be taken, and I was told in advance of the meeting that none would be taken. At the meeting, the committee postponed the item at the call of the chair. I appear before you this evening to request that the chair of the Compliance and Amendments Committee please put on their agenda for their meeting on the 25th of this month a motion to recommend that the task force enter a finding of willful noncompliance against Terry Borer, Harriet Stevens, Balam Vigil, Stephen Vanuelos, Jeffrey Greyer, and Amber Gray, committee chairs, co-chairs, and staff of the commission, and that the task force recommend that the Board of Supervisors dismiss the commissioners and that Behavioral Health Services discipline the staff for official misconduct. The Commission's violations have not abated since your April 6th ruling, nor since the August 23rd hearing. In fact, they have intensified, a fact that is occluded somewhat by the fact that most of the offenses were not complete because the meetings failed to attract quora. This would be our 8th hearing before an SOTF committee on the very same issues with the Behavioral Health Commission since June of last year, and the 11th time they have come before this body and committees. The Behavioral Health Commission has demonstrated beyond a doubt that they are going to continue to violate the San Francisco Sunshine Ordinance for just as long as you hesitate to propose taking enforcement action against them. Back to you, Mr. Chair.
Okay. I believe that is our last person requesting public comment at this time.
Okay, thank you, Victor. We'll go ahead and close public comment. We're about 5 minutes ahead of schedule here, so we'll take a short recess. I actually was able to find a phone number for member Padmanabhan, so I'm going to try to give her a call on our short recess to see if maybe she just wasn't aware of the time change here. And so let's meet back here, it looks like at 8:01 for everyone. Okay, thanks.
Ah, Matthew,
Yes.
I just sent you an email
Okay.
from Jaya. She thought she was sending it to you, I think, and sent it to me instead.
Oh, okay. So it looks like she will not be available.
Yeah, 3 a.m. Yeah, that's hard. So I should have made that available to everyone.
Yeah, make sure you forward those to me, Cheryl. If anyone says they're not going to be
Yeah,
present.
you're right.
Hi, this is Charles Jung. I wonder if people can hear me. Sorry to ask.
We can, yes.
Okay, cool.
Okay, so it's 8:02 now. So if everyone could just turn their camera back on to make sure that we can see you all and you're all back. I'll do a quick roll call to make sure that everyone is present. So Cheryl, when you're ready, if you could just do a quick roll call.
All right. Member Schmidt?
Present.
Member Schmidt present. Member LaHood?
Present.
Member LaHood present. Member Stein?
Present.
Member Stein present. Member Highland?
Present.
Member Highland present. Member Wolf?
Present.
Member Wolf present. Chair Yankee?
Present.
Chair Yankee present. 1, 2, 3, 4, 6. Yep, we have quorum.
Okay, so we still have quorum. Great. So to continue, I'm just going to reopen public comment like the agenda said at 8 o'clock in case anyone could not join us until 8 o'clock and wanted to make general public comment. If you've already made general public comment, you cannot speak again. So this is just for people who have not spoken yet.
If there's any additional parties who would like to make general public comment, we will go ahead and reopen it. At this time, if you haven't already made public comment, I do not see any additional hands raised at this time.
Okay, thank you, Victor. We'll go ahead and close public comment for good on this. We can go ahead, Cheryl, then and move on to item number 8.
Item number 8, file number 22104, hearing regarding request for reconsideration of complaint number 22036, complaint filed by Anonymous against Charles Young, excuse me, Elections Commission for allegedly violating Administrative Code Section 6725 by failing to respond to an immediate disclosure request in a timely and/or complete manner. On August 3rd, 2022, the Sunshine Task Force moved to find that Charles Young of the Elections Commission violated Administrative Code Sunshine Ordinance Section 6721B by failing to respond to an immediate disclosure request in a complete and timely manner, 6725 by failing to acknowledge within 1 business day of receipt of the immediate disclosure request, and California Public Records Act 6253C as in cat by failing to provide notice that there are any disclosable records within 10 days. The Sunshine Task Force also moved to order the Department of Elections to search Charles Young's email address and ask them to reach out to Mr. Young to obtain records in his possession under Smith versus San Jose.
Okay, thank you, Cheryl. And do we have both parties here? I believe I heard Mr. Young, and I believe Anonymous was with us, and so are they both unmuted?
I believe both parties are unmuted at this time.
Okay, excellent. So members, the way this will work, this is a request for reconsideration. This is not the actual reconsideration hearing. This is just a hearing to see if we should move on to a reconsideration hearing. If we go that route, what would happen is that our old vote would be rescinded and we would pick up where we left off at a future meeting that I would schedule it for. And pursuant to our complaint procedures, it says that the petitioner respondent may submit a request for reconsideration of any SOTF order within 30 days, and that did happen here, only in cases where new or pertinent information becomes available. So what we'll do is I'll allow the person who requested the reconsideration, which is Mr. Young, to speak for 5 minutes. I'll allow the initial complainant to speak for 5 minutes. There's not going to be rebuttals in this. So after each party has a chance to speak, we can deliberate and make a motion on whether or not we want to grant the reconsideration or not. Any questions on that? Okay, not seeing any. So Cheryl, when you're ready, please let Mr. Young know and he can begin his presentation.
Mr. Young, are you ready to begin your speech?
Yes, I am. Can you hear me?
Yes, we can. Go ahead, sir.
Okay, great. All right, great. Thank you, everyone. Good evening. This is Charles Young. Appreciate you all doing this. I know this can be a thankless job, so appreciate your work. So I made a timely request for reconsideration relating to file number 22036. So the new information is that I received no actual notice of either the request itself or the hearing. The information request was new to me, as you can see in the file. Also, the hearing notice was new to me, and I first learned of the request itself on August 4th through Twitter. I'm actually not on Twitter, but someone alerted me as to this thing, and you can see through the correspondence that there was some, at least on my end, I was confused as to the actual date. But in any event, same immediately upon learning, I reached out and as soon as I learned about the request, I searched for responsive documents, provided them the same day to the Sunshine Ordinance Task Force, which through Chair Yankee, who then forwarded on to the requester. That was 242 pages. I don't personally have access to sfgov.org, that email account, which I've had the darndest time trying to access over the years. You'll see that people knew not to communicate with me through that address. I attached examples going back through to 2013. It just, I won't belabor those details unless you want me to. But basically, I don't have access to the sfgov.org email address anymore at all, and I assume that I shouldn't try to access it as a former commissioner. And further, I understand that the Department of Elections already has searched for and found no responsive emails. So in short, as soon as I learned about the hearing and the request, responded immediately, did the search. There's nothing else in my possession, custody, or control. You'll see in my response to Ms. Chair Yankee that there's, as I searched the emails, text messages, etc., the entire scope of the request, and there's nothing there. Well, actually, outside of what I've already provided, which is the 242 pages. So that's the substance of it, and that's the new information, and appreciate the consideration.
Okay, thank you. And we'll go ahead and move on to the initial complainant in this, Anonymous. So Cheryl, when you're ready, please let Anonymous know.
Anonymous, are you ready?
Hello, is anyone here?
Yeah, we can hear you.
Oh,
You ready?
sorry, I didn't know I was unmuted. I apologize. Okay.
Okay, are you ready to begin, sir?
I am, thank you.
Go ahead.
All right, good evening. This is Anonymous, the original complainant. I'm going to take this in two halves. I agree with the respondent that the notice, the hearing that SOTF sent never actually got to him because he was a former commissioner at that time. And thus, in the interest of fairness, you should grant the request for reconsideration on that basis alone so that he has a chance to be heard. I would hope that if you do grant the request for reconsideration, that at your actual hearing, you actually give both parties a chance to speak so that we can do a presentation and rebuttal. I understand that you don't have to, but I think you should so we can actually make a presentation. Now, your rules say that you should only grant the request for reconsideration if the answer, your final ruling, would change. And I would argue that your final ruling should not change. It's a separate issue as to now that he's not a commissioner, yes, he can't and he should not access his SFGov email address. However, at the time of April 6th, which is before Jung's last meeting on the Election Commission, which I believe was April 8th or later, he was responsible for responding to requests sent to his SFGov email address. I sent my email to both elections.commission@sfgov.org and charles.jung@sfgov.org on April 6th. I followed the law. He had an obligation under admin code 6721B to respond to mailed, emailed, or phone called, I believe, requests. And also, he tells you on page 20 of this PDF in an email from him to the SOTF on August 4th, quote, "The only time I recall accessing it being the SFGov email address, was before the last meeting I attended." So it's not impossible for him to access that email address. He just didn't access it frequently. And I don't think that makes him immune from sunshine requests. If you do the reconsideration here and you rule against me, that precedent would mean that I didn't file the sunshine request correctly. I could not have possibly known his personal email address. And I also sent it to elections.commissioner@sfgov.org. And so if you set this precedent that he did not violate the law, I will have to, it's bad for both the public and commissioners. It means that I have to now sunshine the clerk of the board for every commissioner's personal email address, and I'm not guaranteed to get a response unless I sunshine both their SFGov email address and their personal email address. I understand that he couldn't set up some sort of forwarding between his SFGov and his law firm address, but that doesn't mean that he shouldn't regularly check his SFGov email address in order to ensure there are no records requests sent there. I just don't know what I should have done here. I sent it to both elections.commission@sfgov.org and charles.jung@sfgov.org. I didn't have any further responsibility. But again, in the interest of fairness, I think you should grant the request for reconsideration, but eventually you should still rule in my favor. Alternatively, Charles Jung can now comply with the ordinance and directly send to me the records, his justifications, the redactions, and I've offered to simply close the complaint after you grant the request for reconsideration, which would mean there would be no violation against him, but there's also no precedent set by you that I have to somehow email personal email addresses. I'm still open to that. I don't think he has responded to that, but he has to send it to me. And if he asks the city attorney now if he still has to comply with requests that were outstanding as of the day he resigned, they will tell him, yes, because that's exactly what they told the redistricting task force members as in an email to you all in the other cases in August. So if he sends me that email after you grant the request for reconsideration and vacate the original OD, I will close this complaint. But he has to send me himself those records, the justifications, etc., because that's the law, and it's not it's not the chair's responsibility. Thank you very much.
Okay, thank you, Anonymous. Members, it's with us now to decide how we want to proceed on this. Or if we have any questions, we can ask questions as well. I'm not seeing any. Oh, I'm sorry, Member Schmidt.
Yeah, I have one or two questions for Mr. Young. First question is, when's the last time you did access that SFGov email account?
To be honest, I don't remember. It's been months and months, and I recall accessing it only once before I left the commission. And after my last meeting at the commission, I informed the city attorney that I would be resigning, or the city attorney's office. And so I don't know. I don't know, to be honest. And
So you were commissioner for how long?
For several years, maybe
Several
9 years.
And you accessed the account once during that whole time?
No, there was a period that I accessed it before, and that was when I was trying to set up the forwarding, which created an infinite loop problem, and I was instructed to stop forwarding. So that's when I did that.
Okay. So at the time you left, as far as you know, you could have checked your emails in that account, correct?
At the time I left, look, I've been able to access it really once in the past several years, and it's kind of a guessing game for me as to my passwords. I have my system files here at work, and I have restrictions, and I don't know whether the problem is on my end or SFGov, but it's only one out of several times when I attempt to access it that I am ever able to access it. That's the difficulty. I know it's probably technically feasible for me to go through security and the IT department and do this and that, but I just didn't have, it was impracticable for me to do that. So it's not for lack of desire, it's just, it was impragmatic for me, which is why I tried to set up this forwarding. So I can understand the frustration, but really everyone at elections knew that I didn't check that. So anyone who wanted to reach me, they sent it to my work account, and that was for years and years and years.
Okay, that's all. Thank you.
Thank you, Member Schmidt. This is Chair Yankee. Mr. Young, I have just a couple questions here, just to get a timeline. What day did you resign?
I didn't officially resign until I believe it was. It was like after that, a month or two after that last meeting. So in other words, I didn't submit a writing, but as of that last meeting that I attended, which was, I think, Mr. Anonymous is probably right. I have no reason to doubt it. Was probably the 8th. That's when I notified the chair and everyone else in the room, including the deputy city attorney, that I was resigning.
Okay, so that would have been. It looks like I'm just looking through the emails here, just for everyone's benefit. It looks like the first notice to the respondent that even a complaint had been filed was on April 14th, and then of 2022, and then that was sent to his SFGov and only his SFGov email address. And then I'm assuming that there were subsequent emails, probably several months later, regarding the committee hearing, and then this was on the August agenda, so I'm assuming that was in July. So this would have been a considerable amount of time, it sounds like, after your resignation.
Right. So, if Anonymous is right, and I have no reason to believe that he's not, that last hearing was April 8, and that's when I notified everyone that I was stepping down.
Okay, and then my second question for you, it sounds like you do have some responsive documents. Would you send those responsive documents to, or is there a problem why you can't send those responsive documents to the requester directly? The SOTF does not, isn't in the position to act as an intermediary. There's a requirement that when someone makes a request for documents, that the response goes directly to that individual. And so even if those were sent to me or to Cheryl, they should also be sent directly to the person who requested them. And so is that something you would be able to do?
I could. I appreciate that I sent it to you and you forwarded those documents onto the requester. I don't see what the difference is. I expressed to you, and I guess I'll just say now publicly that, I feel uncomfortable doing that in the sense that this has felt like kind of a waste of time and harassing. And so I don't like to be harassed, and I'm no longer a commissioner. And so, to be honest, that's why. And I feel like a lot of the correspondence is unnecessarily impolite and uncivil, and I just don't have time for that. So yes, if that's the technical rule, that even though you sent these documents already to the requester, and that it's a violation of admin code 6721B that I didn't send it directly to him and you were an intermediary, yes, I can do that if that's going to satisfy everyone and not waste further time on this. I'm happy to do that.
Okay, yeah, there's nothing to compel you to have discussions with any of them, but to turn over the records directly, I think it's pretty clear that those need to be sent directly to the requester. I think it'd be terrific. I think he's offered to, withdraw this if that were to take place. Like I said, you don't need to have further discussions, but simply forward whatever responsive documents you have to him. I think would be appreciated by all parties.
Okay, that's great. I'm doing that right now then. So hopefully with this, then this matter can be closed altogether in substance.
Okay. While you do that, to the members, this is what I would propose. I think both parties agree that it would be in the best interest, regardless of how this turns out, to grant the reconsideration. My recommendation would be that we do so. That gives the petitioner time to review what was sent over. And if he wants to at that point withdraw, we can close the file. If he does not feel that is a fully set of responsive documents, then we could then pick up where we left off in a future hearing that way. I don't know if there's any thoughts on that.
I would second a proposal if that is a proposal. I was basically going to suggest the same thing.
Member Highland here. Yeah, that seems pretty all-encompassing and allows best possible outcomes on several paths. So I would support that direction. Or I would third that motion, I guess.
Okay, I'm not seeing any other hands, so I will go ahead and make that an official motion. I will move to grant reconsideration in this matter based on the fact that the respondent did not receive the initial notices of hearings from the Sunshine Ordinance Task Force.
I will second that motion.
Great. So that's moved by Chair Yankee and seconded by Member Stein. Cheryl, do you have that?
Hang on. Moved by Chair Yankee, seconded by Member Stein to grant reconsideration in this matter based on the fact that the respondent did not receive official noticing of the Sunshine Task Force meeting.
Yes. Okay, members, any discussion on that item? That motion, I should say. Not seeing hands, so let's go ahead and move to public comment on that.
any members of the public who wish to provide public comment on this item, you can go ahead and raise your hand at this time by pressing *3. I'm not seeing any hands raised at this time.
Okay, thank you, Victor. We'll go ahead and close public comment on that. Members, any final discussion points? Ready for a vote? Okay, Cheryl, when you're ready, please call the roll.
Chair Yankee?
Aye.
Chair Yankee, aye. Member Stein?
Aye.
Member Stein, aye. Member Schmidt?
Aye.
Member Schmidt, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Padmanabhan, absent. Member Highland?
Aye.
Member Highland, aye. Member Neighbors, absent. Member Hill, absent. Member Wolf?
Aye.
Member Wolf, aye. Vice Chair Wong, absent. 1, 2, 6. 6 in favor.
Okay, great. So that motion passes. Thank you, parties, for joining us. Hopefully, this can be resolved in the next, few days or next few weeks, and I hope we don't have to see you back here. But if so, we'll get it scheduled. Okay.
All right. Thank you, everyone.
Thank you.
Thank you.
Okay, before we move on to the next item, I just wanted to note that looks like Member Padmanabhan did send an email to Cheryl, and so she's not going to be here, which means that if we lose Member Stein, we lose quorum and the meeting ends. And so it's 8:25 Pacific time. So Member Stein, before we move on to the next item, is this an item that you can stay in here or not? I don't want to hear half of it and then have to stop.
All right, I'll stay in here.
Okay, well, we'll try to move,
But I just appreciate, because I'm on Eastern Standard Time, so
Yeah.
if we could be efficient and judicious in our comments,
Absolutely.
would be great.
Point well taken. If this sounds like this is something that's going to get complicated, we could always move to continue it if needed.
Okay.
Okay. All right. So Cheryl, we'll go ahead and move on to the next item, which is item number 9.
Item number 9, file number 20084. Complaint filed by Anonymous against Harlan Kelly and the Public Utilities Commission for allegedly violating Administrative Code Section 6721 for failing to respond to a records request in a timely and or complete manner. 6726 for withholding kept to a minimum. 6727 by failing to provide justification for withholding of responsive documents. And 67.29-7A as an apple for failing to maintain correspondence and records in a professional and businesslike manner. On July 19, 2022, the complaint committee found that the task force has jurisdiction, the requested records are public, and referred the matter to the task force for a hearing.
Okay, thank you, Cheryl. And I believe Anonymous is here. So do we have someone from to represent Harlan Kelly or the Public Utilities Commission in this matter? If you could raise your hand by pressing star.
Oh, sorry. Mayada from the PUC is here. Thank you.
Okay, excellent. Thank you. Okay, so before we hear this, this looks like it went to the complaint committee. So complaint committee Chair Schmidt, did you want to give us a quick summary on this one?
Yeah, in some ways it's straightforward, but I do want to make note of a couple of items that sort of jumped out at me in my second time reading through. So, Anonymous made the request. I think it's a very important case, and this is the kind of case that I not that all our cases, they're all important, but this one is one that it matters broadly for the city government, and yet it's been 2 years since the case was initiated, so this is an example of a very, very old case. I know that I play that violin fairly often, but I guess this did strike me that way. Anonymous made a request and he received, his request was made to the PUC. The PUC did apparently contact their person, Harlan Kelly, which is something that Smith v. San Jose requires, and told Mr. Kelly to go search for records. Apparently, Mr. Kelly was asked in whether he was told to redact or he chose to redact. He redacted items himself, then gave the documents to be produced. The documents were produced to Anonymous, and I guess the redactions were sort of like see-through. And so Anonymous immediately told the PUC that had happened because Anonymous was going above and beyond, let's say. And because also he saw a code that might be a private code. Now, these were, they're a redacted version. The PUC then told Anonymous to destroy. In fact, now they say that they demanded that he destroy. I think that in itself is very, I'm a little bit taken aback by that. And they demanded it based on the Arden case, which involves inadvertent disclosure. I'm not quite sure if Arden would apply outside of attorney-client product documents to this kind of situation and privacy. And I'm not sure if all the factors or the standards in Arden are satisfied here. I believe that one thing that I saw also was that I'm not quite sure. Well, the redactions seemed like they were excessive. They weren't keyed, and somehow in the end we know that they were excessive and they go outside of the proper scope of what privacy redactions would be. And I want to note that on page 541, the PUC actually wrote a letter where this is the closest I've seen to an accurate description of what actually the right to privacy protects, which is a lot narrower than what we're seeing in any other case. And so I wanted to point that out because I believe that we need to really be less open and forgiving when someone says, oh, it's private, not going to produce it, boom. There's some keying problems here. I don't know if Anonymous wants to ask for any kind of a willful violation. And I think that's everything I saw. I apologize, but I thought that these notations might be important, not just for this case, but for future cases. Member Stein or Member Wolf, do you have anything to add to that?
I will just say quickly, I thought that was a good summary of the case. And in case not everyone has seen this, I did just see an email from Anonymous that just came over saying that they're having trouble with their phone connection to the web conference. So if we call on that person and there's no response, that might be what's happening.
I concur.
Okay. Thank you, everyone. So we're going to try to hear from Anonymous now. Anonymous, can you hear us? Is your connection working now?
I can, but WebEx has kicked me off 2 or 3 times now. So yeah.
Okay. Hopefully we can get through this. If not, we'll try to wait for you to get back on here. So while it's working, Cheryl, when you're ready, please let Anonymous go. We'll give him 5 minutes to present, and then we'll move on to the respondent in this case.
Anonymous, are you ready to begin?
I am.
Go ahead, sir.
So I would concur with much of what the complaint committee said, but I want to clarify one thing. This request was not made only to the PUC. It was actually made to Harlan Kelly's email directly also. That's why I've named him as a respondent and the PUC. And he directly got this request from me. It's not only routed through the PUC. Anyway, so in chair, the complaint chair is very correct. This is either my most important or one of my most important complaints because the actual records produced had significant effect on real life, right? So in June, I made a request by email to Harlan Kelly and the PUC for, among other things, for text between Kelly and Wong based on a tip I received from a source about their relationship. Kelly produced those text messages in native format with metadata and merely highlighted instead of actually redacting various portions of those texts. Those incorrectly redacted texts reflected the mixture of public business with private business that Kelly was later federally charged with. But in one of the texts, a password for Kelly or Wong was disclosed, so I informed PUC, who purported to retract the records from me and reissued a vastly redacted version. After realizing what the content of those now redacted messages were, I filed this complaint immediately and also informed the city attorney, alerting them to this. In November, Harlan Kelly was charged with corruption-related crimes, and the filing by the DOJ numerous times quotes from these texts that were produced to me, both the ones he didn't redact and the ones he did redact. Now, I think this is an open and shut case, and the reason is because they changed their mind N months after my complaint and unredacted the records. And that proves that they were non-minimally withheld. So no matter what else you do, you should find the violation for non-minimum withholding under 67.26. And you can see that on page 83 of the PDF. In February 2021, PUC sent a letter to me, changed their course, and produced nearly all of the text messages. Also, you should realize PUC does have a copy. It's not just on Harlan Kelly's personal devices. Now, on page 313 of the of the PDF, PUC states that violations 1, 2, and 3 have, quote, have been addressed and resolved. And that is their amended response to the complaint sent to the task force. They, in fact, agree with violation 2. They say that their new production basically fixes violation, I think it's 3. I think they deny the 6729-7 one. Based on that letter and based on the fact that I was exactly right, you should find the violations. I'm actually not certain why PUC is here defending this complaint. I assume their argument is that the later department heads, Michael Carlin and Dennis Herrera, should not be held responsible and the PUC currently should not be responsible. I don't actually have a problem with that. I am not naming them as respondents. They weren't there when the complaint was filed. And the chair of the complaint committee asked me during the complaint committee, in addition to the violations, am I still asking you to order the current PUC to disclose the remaining redacted records? And I said I would consider it. And so because that might endanger the identity of my source, I am not going to show you any further evidence of what might be in those text messages or order you to, or ask you to order them to produce the remaining unredacted text messages. But just to be very clear, I was exactly right, right? I made the request. I noticed that there was this mixture of public business and private business in the supposedly redacted text. I filed a complaint, and for whatever reason, they took until February and March to then unredact the records and produce them. I am not asking you to find that Dennis Herrera or Michael Carlin, who are the later department heads, violated the law, merely that Harlan Kelly did. And if their argument is that the PUC should not kind of be responsible for what Harlan Kelly did, that's fine. You can find the violations just against Harlan Kelly. In fact, 6729-7 says that it is a department head's responsibility not merely to maintain the records, which is not my alleged violation here. He did maintain the records, but also to disclose them in accordance with the Sunshine Ordinance. And Harlan Kelly did not do that. So I am not asking you to order the current PUC to order disclosed what they claim are now purely personal text messages that they have on their computer systems, merely to find the violations. And I don't see how you can not find the non-minimum withholding violation, because clearly in June and July, vastly more text messages that should have been redacted were redacted. I'm not asking you to change any Smith versus San Jose processes. I don't think you have any ability to tell the city that. I'm simply saying they gave me text messages. Those text messages were over redacted. That is a non-minimum withholding. And there's no way they can avoid that finding since they themselves came to the conclusion in months later on that actually, yeah, they should have produced and then did produce a bunch of those text messages. So I'm happy to go into any more of this detail. This has been discussed in the news quite widely, so there's nothing secret about this anymore. It's a long time after it happened, but yeah, you should find the violations, and I am not asking for any order to disclose additional communications. Thank you very much.
Okay, thank you, Anonymous. And are there any parties to provide facts or evidence on behalf of the complainant? And seeing none, we'll go ahead and move to the respondent. So Cheryl, when you're ready, please let the respondent know when they may begin.
Ms. Ruski Augusta Saw, you ready to begin?
I am. Thank you. Let me know when I can start.
Go ahead.
Thank you. I'm here representing PUC. The complaint was brought against Harlan Kelly and PUC. So I am here representing SF-PUC. I do not know if Harlan Kelly knows about this since he has retired, but I'm here to talk about the facts of this case and, the approach that PUC took while responding to this request and this complaint. So Anonymous is correct that we did send a letter to the task force on March 5th, 2021, to notify the task force that all the alleged violations raised in this complaint were addressed and resolved. We did send a letter to Anonymous himself on February 22nd of 2021, and both letters are included in the packet. And the PUC letter sent to the complainant did provide a minimally redacted version of the exchanges between Mr. Harlan Kelly and Mr. Walter Wong. And we also explained at that moment that the redactions were made by Mr. Kelly himself. So as referred to previously by Anonymous, the complaint alleges 3 violations. Violation number 3 alleges that PUC provided an incomplete response to a records request and engaged in unlawful and non-minimal withholding. So following the standard practice of city departments, the general guidance of the city attorney's office, and the city of San Jose guidance, PUC relied on Mr. Kelly to prepare the redactions in the version of the document that we produced to the complainant at first. And Anonymous is correct that he did brought to our attention that the redactions were probably not applied. That's why he could remove them. That's my assumption. So due to the unique and extraordinary circumstances and events that followed the disclosure of that record related to the federal criminal charges that were brought against Mr. Kelly and Mr. Wong, the PUC, in consultation with the city attorney's office, undertook our own review of that unredacted document that was still in city's possession. And then PUC determined that additional messages should be unredacted, and then a new version of the record was provided to Anonymous on February 22nd of 2021. The new version only kept redactions of the matters that were clearly private or clearly unrelated to city business. The second violation was that we failed to identify all persons responsible for denial of access to records. We, in fact, did not provide the name or title of the person responsible for those redactions, but that was an oversight. When we realized that had happened, we did send a letter to Anonymous to let him know that Mr. Kelly himself had made those redactions to the original document. And since this was brought to our attention, it is now our standard practice to provide name and title of the person responsible for any redactions or withholdings. So that is something that I'm very careful, and it has been added whenever we're redacting or withholding. It was clearly an oversight. I will admit I was not familiar with that rule until this case brought that to my attention. And then the violation number 1 alleges that Mr. Kelly failed to disclose all of his correspondence with Mr. Wong. As you're all aware, Mr. Kelly resigned from city employment in 2020, and we produced all of the text messages that we had in our possession between Kelly and Wong, and we do not have anything else to produce. So I respectfully request that this complaint be dismissed, at least when it concerns PUC, as PUC properly did what we could. We asked Mr. Kelly to search his records. He redacted his own records. And when the extraordinary circumstances arose, we did produce a new version that was minimally redacted.
30 seconds.
To comply with law. So that's it. Thank you.
Okay, thank you. And are there any parties to provide facts or evidence on behalf of the respondent? Not seeing any. So members, this is our portion to ask questions if we have any. So I'll turn it over to everyone if you do. I see Member Schmidt waving his hand.
Yeah, first to the respondent. At the time that the Harlan Kelly redacted version was in the hands of the PUC and was being produced to Anonymous, did you did the PUC also have in hand an unredacted version of those same documents?
I am not sure. I started working with PUC in 2020, and the person who was handling public records at that point has left PUC. So piecing together every fact here is a little bit trickier. But my understanding is that Harlan Kelly provided the improper redacted record to public, and because the black boxes existed, I'm assuming they assumed redactions were properly made and didn't realize that the black boxes could be removed. So I assumed that that version existed at some point.
Okay. When did the PUC have an unredacted version available to it?
I'm sorry?
Well, as we know, in February of 21, the PUC was in possession of an unredacted version of these same messages. And I'm wondering how far back had the PUC had that unredacted version?
I'm not sure if PUC had that unredacted version. I believe, I'm certain that maybe the person that was handling public records before I was hired maybe had a version somewhere in their computer.
Okay.
But my understanding is that the unredacted version that we later produced with minimal redactions might have come from litigation or the investigation. I am not privy to those details, but I believe that it is possible that it didn't necessarily come from PUC. It might have come from the city attorney's office or some other branch.
Okay.
I was not part of that new review, let's put it that way.
So you're not sure how it's sort of suddenly appeared, where it came from, et cetera, et cetera?
Yeah, I was not involved in that process.
Okay, thank you. And to Anonymous, there's one thing, there's a mention in a few places in the file, but I'll just cite, you had also asked that the attachments that Mr. Kelly's messages refer to that were not included in the production, you've asked that those also be produced to you. And as far as I know, none of them have been. Are you seeking an order today that those attachments be given to you by the PUC? And again, that's a question to Anonymous.
Victor, I think he needs to be unmuted. If you could unmute the parties again.
Member Highland here.
Hi, sorry.
Oh, he's back. Good.
Hello.
Okay, yeah, we can hear
Sorry,
you.
it's been kicking me out many times, so I just got back on. What's going on?
Okay, I'll ask a question again. This is Member Schmidt.
Okay.
You had noted somewhere in the process that the messages you did receive from Harlan Kelly had a lot of attachments that were not included, and you have requested that you receive the attachments, and then the PUC said that they, quote, presumed that Harlan Kelly didn't give them to you because they're all somehow not producible. Do you seek an order here today that the PUC be ordered to provide you with those copies of those attachments?
Yes, not the text message with the attachments. I want to be very clear, right? Because I'm not asking for text messages, like the text content, correct?
Thank you. That's all.
Yeah. Hold on. I'm asking you. Are you asking me that question? Sorry.
Well, I'm wondering if you want an order that would order the PUC to produce copies of those attachments.
Okay, so I'll answer that in this way. I would love that, but I don't think you'll be able to. I don't think they'll be able to actually effectuate that order, and the reason is related to what I heard. Some part of what the respondent was saying that about how what record they have. I can tell you what record they have because I know about it. They have basically the thing that Harlan Kelly did not correctly redact, right? And that doesn't have the attachments in it. They just have the thing without the highlighter, right? And so they can remove the highlighter blocks, but I don't think they can give me the attachment. So.
Okay. Although, okay, it sounds like you would not reject having such an order as part of your order.
Absolutely, I would love such an order. I just don't think that they will just not be able to comply. So, yeah.
Got it. Thank you. That's all.
Okay, thank you, Member Schmidt. Other members? All right, I have a quick question for Anonymous. This is Chair Yankee.
Yep.
I think you'd mentioned a violation for 6727 for not noting or keying their redactions, and I'm noticing there obviously are a lot of redactions without keys next to them. Is that a violation you're still seeking?
Well, I think yes, in the sense that as this task force has held many times, the fact that later on after the complaint you decide to give people follow the law is not relevant, right? You have to follow the law at the beginning. So on that basis, yes.
Okay. Are there any remaining redactions that you believe aren't keyed when you got the revised version?
They did not use keying, but their argument that the remainder is completely personal or it is personnel information, right? So the former is not a public record and the latter is a public record but is exempt. I don't think they are making any other argument, and so I'm not asking you to have them more carefully redact anything. So.
Gotcha. Okay. Okay, members, any other questions, or should we go ahead and move to rebuttals? Not seeing any hands, and so in the interest of time, let's go ahead and move on to rebuttals. So rebuttals, we go the opposite direction. We have the respondent go first for 3 minutes, and then we have the complainant finish up. So Cheryl, when you're ready, please let the respondent know when she can begin.
Mayara, are you ready to begin?
I am.
Go ahead.
Yeah, just going back to your last question, Chair Yankee, yeah, that is, Anonymous was right. We read the information that was redacted at the minimally redacted version. It is basically all, it's either not city business, right? And it is all personal. So it's things that relate directly to like family. It's like references to family illnesses, to children, personal residential addresses, cell phone numbers, and there's one, I think, personal matter in one of the pages. So it's not keyed, but at the end of the day, it is all private information, especially because personal information kind of like overlaps with private. So it is not keyed, but at the end of the day, the umbrella redaction is the category is privacy for all the redactions. And again, just repeating myself here, but PUC followed the standard procedure and asked Mr. Kelly to provide his records. And I do agree with Anonymous that I don't think we have a way to extract any attachments. I think it's really some images or something. I can't really tell what they are from the text messages, because once you provide a PDF, you can no longer extract that, right? I think those records only exist in Mr. Kelly's cell phone, which we no longer have access to. So that is like it's something that we could not achieve at this point, regardless of the PDF being an unredacted or redacted version. The matter of fact is that you cannot click on anything when it's a PDF. But yeah, I think PUC acted properly when asking Mr. Kelly to provide his records, and he redacted those records. When we learned this extraordinary circumstances, we went back and provided a minimally redacted version. And that's all we can do, and try to do better moving forward. Like I said earlier, I'm very careful that we are adding name and title when we're withholding records or redacting records, to not, commit that violation ever again. And we no longer have a way to ask Mr. Kelly to produce anything. So the portions of the complaint that are against Mr. Kelly, unfortunately, there's nothing really that PUC can do to address that. Thank you.
Okay, thank you. And Cheryl, when you're ready, you can let Anonymous know when he can begin.
Are you ready to begin?
Yes, I am.
Go ahead.
All right. Thank you. I think this case is very straightforward. At the time I filed the complaint, there's no way to deny that I had gotten a minimally withheld record, that I had gotten all the correct justifications, that I had been told the name and person who had done the redaction. In fact, if they had told me that Harlan Kelly was personally responsible for what had happened, things might have turned out differently, but they didn't. They admit the last one, and for the other cases, they have now produced 6 months after I filed the complaint, even more maybe, the less redacted version, which proves I was right? Normally, it's very hard for a member of the public to prove that something that was redacted should not have been, because we don't know, but I knew what was in there, right? And I told them this, and I told the task force this, and I told the city attorney this. And there was no reason. It doesn't matter what process they used. I'm not arguing that they have to change their process, that whether or not they should do something different in light of some city attorney's memo at Smith versus San Jose. That's not what the law says. The law just says you have to provide me a minimally redacted record. You have to provide me justification. You have to provide me the keys. You have to provide me the name and person who did the redactions. That's the law. And if their policy internally sometimes screws up and doesn't effectuate the law, maybe you should change that policy. But that's not what I'm asking you to do. I'm simply asking you to find that Harlan Kelly violated these laws, because there's no way to argue that he didn't, given that we now have the less redacted records. I will say it's not necessarily the case, now that she has explained what they might have, that they would be impossible to produce the attachments. That PDF is often generated using a source file that you keep on the computer. There's a tool that generates that PDF from a source file. And if that source file is still on the the city-owned computer for Harlan Kelly or anywhere in their mainframes, they can still produce those attachments. It'll be stored in those XML databases. So I don't know if they still have it. If they do have it, they should produce it. They may not even know that they have it, but if they have the source record and not just the PDF somewhere on a city-owned computer, they should produce it. But I'm not asking for any of the other text messages. Again, I know what's in the text messages, and there is personal information in there that I'm not asking to be disclosed, the textual content itself. So, yeah, I think you should find the requested violations. I don't see how they can avoid a 6726, 6727, and the failure to note the person who was responsible. I just don't see how those three cannot be found. And maybe this will signal to future public officials that you should not try to hide your mixture of public business and your friends in corrupt ways from the public. That's all. Thank you very much.
Okay, thank you, Anonymous. All right, so members, this is our time to deliberate and formulate a motion on this. So any thoughts?
Yes, I'll just say that this is Member Stein. I feel like, yes, I think all of the alleged violations definitely apply to Harlan Kelly. I tend to think that once the PUC does have all of these records in their possession, even if it's a mix of personal and governmental dealings in those records, it is incumbent on the PUC to then choose what is redacted. And to me, it seems clear that they over-redacted. That's kind of where my thinking is.
Okay, thank you, Member Stein. Anyone else? Are we ready for a motion on this?
I don't think anything anonymous requested here is out of it seems like it's all pretty clear that there's violations, and what anonymous is asking for is all applicable.
Did you want to take a stab at a motion there then?
I think you have it more concisely in your mind, Member Schmidt, if you want to do it, along with what you want to be able to request from the PUC.
Sure. I'll take a shot then. I move to find violations against both Harlan Kelly and the PUC. The violations being Administrative Code 6721B, failure to respond in a complete manner. Oh, also let's add Government Code, I think it's 6253 on that, since this was in 2020. The second violation is Government Code 6253D, failing to identify all persons responsible for denying access. And then 6726, failure to keep withholding to a minimum. 27 for not providing a specific justification for certain withholdings. And also to include in the order that the PUC produce any and all attachments to the subject emails that were sought in Anonymous's request. That's all.
Okay, so then I'm just going to try to read back what I think you have, just so everyone knows. Okay, So it looks like to find both Harlan Kelly and the PUC in violation of, looks like 6721B for not responding in a complete manner. Then it looks like it's Government Code 6253B for also not, responding in a complete manner. Government Code 6253D3 for not identifying the name and title of the individual who did the redactions. 6726 for failure to keep withholdings to a minimum. 6727 for not providing justification for those withholdings, and to order the PUC to respond with any and all attachments to the subject records that's in their possession. Is that
Perfect.
okay?
Okay.
Sure. I'm gonna have you read it now, Cheryl.
Fine. Moved by member, who was the second?
We're not on that yet. I just want to make sure that everyone knows what they might be seconding. So.
All right. Moved by member Schmidt to find violations, plural, against Harlan Kelly and the PUC of 6721B for failure to respond in a complete and timely manner. Government Code 6253B as boy.
B, yep, boy.
For failure to provide responsive records. 6253D as in dog for failure to identify all persons denying access. Is that correct?
Yeah, all persons who were responsible for denying access.
Persons.
It's actually D3 if we want to be more specific.
D3?
D. That one's D. There was a B also before that.
Right.
So the first one was 6253B. This one, Cheryl, is 6253D as in dog.
D3 as in, is that correct?
Correct.
D3, dog 3.
Dog 3. For failure to provide, failure to identify all persons denying access.
Responsible for denying access.
And titles.
For all persons, names and titles.
Yeah, for all persons responsible for the denial.
For denying access. 6726 for failure to keep withholding to a minimum. 6727 for failure to provide a justification for withholding. And include an order that the PUC produce any and all attachments to the emails that were sought by Anonymous in his request.
I think there may have been more than emails. I think there were also text messages. I think we want to say
emails
and records.
Sure.
Yeah,
So,
more than just emails.
Emails and text records.
Yeah. Okay, so that's the motion. Does anyone want to second that?
I'll second that, member Stein.
Okay.
I was going to do that. Okay.
Oh, you can do it. Go ahead if you'd like.
You can. It's fine.
Okay.
I heard member Stein first, so we'll call that one seconded by member Stein. Okay, so moved by member Schmidt, seconded by member Stein. We heard the motion. Any discussion on that motion? Not seeing any hands, so we'll go ahead and turn this over to public comment. Victor, when you're ready.
Yes, it appears that everybody has their hands raised right now. So I'll go ahead and unmute the one person I think who is new to the discussion.
Okay.
Can you hear me now?
Yes.
It is David Bilfeld. Okay, so I listened to much of the discussion on this and have the following observations to share. In my opinion, PUC should include the name and title with responses to PRA requests and communications to this task force, and not just sign things SFPUC public records, or whether it's Myara or somebody else. I think it's important to know the name and title of the person communicating. In my opinion, the PUC and all city departments should request electronic records from an individual with custody of those records pursuant to the San Jose case, and it appears that that did happen here, but PUC and all city departments should conduct its own redaction review and not rely on the custodian to selectively redact however they're choosing to redact, et cetera. I think regardless of whether the source of the records is a physical file or email within a system or electronic records provided by an individual with custody, the process for that redaction should be consistent and should be conducted by the department with the guidance of the city attorney, but should not be subbed out to the individual with custody over the records. That seems unusual and inconsistent to me, and can lead to these kinds of results. And finally, I think the city attorney should clarify the obligations of former city officers and employees. It's not just in this case, but also in the other cases that you heard recently related to the redistricting task force and the elections commission and others. What someone's obligations are when they're in office or an employee is pretty clear. Once they leave that office or employment, it is less clear, and having some specific guidance both to this task force and to affected city officers and employees and city departments generally, I think would help the cause greatly. I don't know what the right answers are to those things, but somebody should figure those out, and we should be consistent on applying that advice. Hope that helps, and I don't know how it relates to the actions before you. Thanks for listening.
Okay, thank you. Do we have any other public commenters? Victor, just double checking.
Okay, I believe the other two parties are, two callers are party to the matter.
Gotcha. Okay, so we'll go ahead and close public comment. Members, any last comments on this before we vote? Not seen any hands, so we'll go ahead and Cheryl, when you're ready, call the roll, please.
Member Schmidt?
Aye.
Member Schmidt, aye. Member Stein?
Aye.
Member Stein, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Padmanabhan, absent. Member Highland?
Aye.
Member Highland, aye. Member Neighbors, absent. Member Hill, absent. Member Wolf?
Aye.
Member Wolf, aye. Vice Chair Wong, absent. Chair Yankee?
Aye.
Chair Yankee, aye. 1, 2, 3. We have 6 in favor.
Okay, so that motion passes. Thank you, Anonymous. Thank you, Ms. Sa. I think we're all set with this item.
Thank you.
All right. Thank you so much, Member Stein, for sticking with us.
We don't need quorum for these next two items.
We do, but if you want to
Okay, I'll
leave,
stay.
we could.
I'll stay.
Okay. Cheryl, the next item, please.
Item number 10, announcements, comments, questions, and future agenda items by members of the Sunshine Ordinance Task Force.
Member LaHood.
Yes, so I would like to mention something that I plan to add to the agenda for the Compliance and Amendments Committee meeting in October. We've had some previous discussions, people asking about making presentations regarding possible amendments to the Sunshine Ordinance. To avoid some issues that have come up, what I would like to do is provide an opportunity for an open call for any member of the public or group that wants to make a brief, to submit any supporting documents that we can add to the agenda. And that's why I'm stating this much farther in advance than we usually put out the agenda. An opportunity to submit any documents and make a brief presentation. We will be giving anyone who wants to participate equal time. I'm planning for 5 minutes, but depending on how many participants we get, we may have to limit that. And we will take public comment on these as well. So I want to make sure that we're offering equal opportunity to anyone who wants to do this at the next Compliance and Amendments Committee meeting. That's it.
Thank you, Member LaHood. That sounds very good. Anything else, members? Oh, Member LaHood again.
One last thing, I want to apologize. When I was signing in for this meeting, I was typing very quickly and there's a lag on my keyboard. My name is misspelled and I was trying to alert Victor to see if he could change it. There are many more letters in what appears on the screen and what may appear in the records. That's incorrect. My name is Lila LaHood. There's some extra syllables. Please ignore them. Thank you.
Duly noted. Okay, anyone else? If not, we'll go ahead and move to public comment on that. And public comment specifically on the topic that Member LaHood spoke about, including her typing is fair game.
Okay, I'll go ahead and unmute Mr. Pelpel.
Great, David Pilpel again. Thank you to Member LaHood. That's one La, one Hood. LaHood. I will consider her suggestion or offer and go back and find my suggested amendments to the ordinance and see if I want to complete those and bring them forward for the CAC meeting. But I have stuff that I have worked on for many, many years in that regard, and we'll consider whether it is timely and appropriate to bring that forward at this time. Thank you for that work, and I will also catch up with Cheryl on anything I missed earlier through the holiday. Thanks again for listening.
Okay, thank you, Mr. Pelpel. Do we have anyone else?
Okay, I believe Anonymous has his hand raised. I don't know if he wanted to make public comment.
Yeah, I did. Am I unmuted?
Yes.
Okay. Let me know when I may begin.
Go ahead, sir.
Thank you very much. This is Anonymous number 3. I think what Member LaHood is doing is fantastic. I know there's some response to an issue brought up by Member Neighbors. I hope this is what you all always do when there are contentious topics, or just any topics, that you have an open call for presentations or materials by anyone, and that every person gets equal, or entity gets equal time. I think it's a great idea. I guess this is a future item. You've forgotten a future agenda item that you put on your agenda last time. I don't know how to address that, but I thought you were supposed to address in the future agenda item the suggestions made by Member Schmidt to streamline simple cases. I thought that was supposed to happen today because it was a future agenda item from last time. But anyway, thank you very much.
Thank you, Anonymous. And I'll just address that. This meeting had to be a special meeting because of various quorum issues and the Yom Kippur holidays. We had a special meeting with a much smaller agenda than usual, and those items will be put on the next agenda for our November meeting, so we can have adequate membership and time to discuss them thoroughly. So that's why those didn't appear here. Okay, any other further public comments?
There are no other members of the public in line to speak.
Okay, thank you, Victor. So we can go ahead and move on to the next item. And maybe we can give this one to Member Stein to do.
Item number 11, adjournment. I have 9:17.
Oh, Member Stein muted.
Member Stein, I move to adjourn.
Okay, moved by Member Stein. I will second that. All in favor, say aye.
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 Opposed, say
Aye.
nay. All right, unanimously
Aye.
approved. Good night, everyone. Thank you for joining us, and we'll see you in November.